Hi, my name is Tyler Pate. My presentation will be on discrimination at the workplace. Title VII of the Civil Rights Act of 1964 and its amendments prohibits job discrimination against employees, applicants, and union members on the basis of race, color, national origin, religion, and gender at any stage of employment. It prohibits discrimination in the hiring process, discipline procedures, discharge, promotion, and benefits. Title VII also applies to employers with 15 or more employees and labor unions with 15 or more members. The Equal Employment Opportunity Commission monitors compliance with Title VII. An employee alleging discrimination must file a claim with the EEOC before a lawsuit can be brought against the employer. The EEOC may investigate the dispute and attempt to obtain the parties' voluntary consent to an out-of-court settlement. Some basic questions that will be answered throughout the presentation. What is employment discrimination? What rights do employees have? What are some examples of illegal employment discrimination? What are the statistics for discrimination at the workplace? And how do employees file a complaint? There are two types of discrimination, unintentional versus intentional. Intentional discrimination by an employer against an employee is known as desperate treatment discrimination. Because intent may sometimes be difficult to prove, courts have established certain procedures for resolving desperate treatment cases. Unintentional discrimination. Employers often use interviews and tests to choose from among a large number of applicants for job openings. Minimum educational requirements are also common. Some employer practices, such as those involving educational requirements, may have an unintended discriminatory impact on a protected class. Desperate impact discrimination occurs when a protected group of people is adversely affected by an employer's practices, procedures, or tests, even though they do not appear or mean to be discriminatory. Ruby Tuesdays is currently going through a lawsuit at their Park City, Utah location, which advertised for temporary summer positions in 2013, complete with free housing and paid expenses, and then allegedly only hired women for those positions because the restaurant didn't want to deal with the hassle of building co-ed housing. The EEOC is currently suing on behalf of Andrew Herrera, who worked in an Oregon Ruby Tuesday, and Joshua Bell, who worked at one in Missouri, both whom applied for the positions. A key case I will be covering in my presentation is Vance v. Ball State University. While working at Ball State University, Mayetta Vance contended that Sandra Davis, a catering specialist, had made Vance's life at work unpleasant through physical acts and racial harassment. Vance sued her employer, the university, for workplace harassment by a supervisor. To win a lawsuit for harassment under Title VII of the Civil Rights Act of 1964, it is necessary to show that the employer is negligent in responding to complaints about harassment. However, to win a lawsuit for harassment by a supervisor, the employer does not have to be negligent because Title VII imposes the supervisor's acts to the employer. Vance asserted that Davis was a supervisor. Ball State claimed the opposite. The District Court in the 7th Circuit of Appeals had determined Davis was not Vance's supervisor because Davis did not have the power to direct the terms and conditions of her employment. Indiana has recently undergone a policy change as of March 30th in the latest controversy over religious liberty and gay rights. Indiana has become the 20th state to enact a Religious Freedom Restoration Act. Many have denounced the law for inviting discrimination against gays and lesbians, and a number of organizations have threatened to move events out of Indiana or to limit their business in the state. In signing the bill, however, the Governor Mike Pence dismissed his criticism. He declared that the law was not about discrimination, but it was added to bolster First Amendment rights. Throughout this presentation, I mainly focused on the legal issues that arose from Vance v. Ball State University. The main issue was if Sandra Davis could be considered a supervisor in the case. The Supreme Court used a narrow interpretation of the term supervisor, so that a person may only be considered a supervisor if he or she can take tangible action against the employee. The rules of law announced in court decisions constitute another basic source of American law. These rules include interpretations of constitutional provisions, of statutes enacted by legislators, and of regulations created by administrative agencies. Today, this body of judge-made law is referred to as case law. Case law, the doctrines and principles announced in cases, governs all areas not covered by statutory law or administrative law and is part of our common law tradition. Recently, a group of 3 scholars, Stephen Wood, Joanne Brackeen, Karen Nyving, did a test to determine the discrimination and well-being of organizations. The goal of their testing was to determine if discrimination in the workplace affects an individual's performance and work negatively. After months of monitoring those who had reported being harassed or discriminated against in the workplace, they came up with the results. An individual's performance is negatively affected when harassed or discriminated at their place of work. The performance worsens the higher up the one doing the harassing is and the more powerful position they hold. The results of the Vance v. Ball State University ultimately defined supervisor and Title VII liability. In defining supervisor for the purpose of Title VII, Justice Alito, on behalf of the majority, relied on the reinstatement of agency principles in finding that in order to find vicarious liability, a supervisor must somehow be aided in accomplishing the tort by existence of the agency relation. Specifically, the court noted that vicarious liability is appropriate where the supervisor takes a tangible employment action against the employee or where, because of the agency relationship, the harassing conduct takes on a particularly threatening manner. In her article, Who Really is the Supervisor in Your Office When It Comes to Your Liability in a Hostile Working Environment, Susan Olson describes how this question is answered thoroughly in the Supreme Court case Vance v. Ball State University. An employer's liability for workplace harassment may depend upon the status of the harasser. If the harassing employee is the victim's co-worker, the employer is liable only if it was negligent in controlling the complaining employee's working conditions. In cases in which the harasser is a supervisor, however, different rules apply. If the supervisor's harassment accumulates in a tangible employment action, the employer is strictly liable. In my opinion, the ruling on Vance v. Ball State University is accurate and now clearly defines the question of who the supervisor is and what their role is. Before the case, the role of supervisor was not clearly defined. Now, due to the ruling, employees know a supervisor is only considered to be someone who has direct power or control or authority over their actions at the workplace. In conclusion, Title VII and various state laws protect employees and their rights thoroughly. Title VII of the Civil Rights Act of 1964 also prohibits government employees, private employers, and unions from discriminating against persons because of their religion. Employers cannot treat their employees more or less favorably based on their religious practices or beliefs. An employer must reasonably accommodate the religious practices of its employees unless to do so would cause undue hardship upon the employer's business. Under Title VII and other federal acts, employers are forbidden from discriminating against employees on the basis of gender. Employers are prohibited from classifying or advertising jobs as male or female unless the employer can prove that the gender of the applicant is essential to the job. The Pregnancy Discrimination Act amended Title VII and expanded the definition of gender discrimination to include discrimination based on pregnancy. Title VII also covers several laws prohibiting employers from engaging in gender-based wage discrimination. The Equal Pay Act requires equal pay for male and female employers working at the same establishment doing similar work. The employee proving a constructive discharge is also covered in Title VII. The employee must present objective proof of intolerable working conditions which the employer knew or had reason to know about, yet failed to correct within a reasonable time period. And overall, the Vance v. Ball State University case provided clarification and gave a more in-depth ruling on discrimination and who is to blame for the harassment of an employee.